Great. Good morning, everyone. Thank you for joining us today on our webinar, Raising Capital 101. That is part of our series with the BLG Driven by Women initiative. I want to thank Julie and Lauren for joining us today as our panelists, and we will get to them in just a few moments. My name is Carrie Lee Auger, and I am the Skills Development Manager here at Women's Enterprise Center, and I work out of our Kelowna office. And I have the pleasure of overseeing our training programs, all the skills development, which includes mentor advisory forums and webinars such as this. So again, we're talking raising capital today, but if there's other topics where you need support, please do reach out to us and let us know a topic that we could consider for another event such as this. So please be sure to complete the follow-up survey that you're going to get after this to share your ideas. Women's Enterprise Center is a nonprofit organization. We're devoted to help BC women start, lead, and grow their own business. So our services include loans of up to $150,000, again with access to additional capital through a new partnership with BDC. We also provide business advice, skills training, mentoring, resources, and a supportive community to help women entrepreneurs realize their business potential. And we do this from our offices located in Kelowna, Vancouver, and Victoria. And our passion is to empower women entrepreneurs to their business success. And we are funded by the federal government through Western Economic Diversification as part of the Women's Enterprise Initiative, which includes similar organizations in Alberta, Saskatchewan, and Manitoba. And you can learn more about this at wec.ca. And we're also very pleased to have received funding as well through the Women Entrepreneurship Strategy, which was just announced in June, so that we can offer more of these services and enhance our services to more women across the province as well. So stand by for more information on that. So now on to today's exciting session, Raising Capital 101. So to answer your questions this morning, I'm very excited to have Julie Bogle and Lauren DeGoy from Borden Ladner Gervais, and they are both associates working out of the Vancouver office. And today they are going to help us understand the stages of financing that are right for you, risks for each stage of financing, some of the documentation that's going to be required and what you can expect, how the structure of your business can affect your ability to raise capital, and also some of the funding programs and tax credits that are available to business. So now I'm going to throw it over to Julie and Lauren, and bear with us for a second because we're going to do a quick opposite share screen. So Lauren and Julie, go ahead.
Thank you. While we kind of do that technical switch,
yes,
I'll give you a little bit more background on kind of what Lauren and I work on. So we do work with we both work in the Securities and Capital Markets group. And so we work with a number of public companies as well as private companies. And a lot of the work we do is with the tech industry. Being in Vancouver, we work with mining companies. We have some cannabis clients, some pharmaceuticals, some media, real estate. So really a broad range of companies. We work with a broad range of companies at different stages. And we personally have a lot of experience in fundraising because of the securities aspect of our practice. So I'm going to turn it over to Lauren now, who will kind of take us through. Oh, sorry, before I turn it to Lauren, I'm going to tell you a little bit about what Driven by Women is. So Driven by Women is all about getting more women into leadership positions. And one of the ways that we do that is trying to partner with and help female entrepreneurs grow and scale their businesses. So we've got, if you're just starting out, we've got a startup and grow package, which is kind of a fixed fee bundle of documents that typically companies need within the first year. If you're more advanced, we've helped companies do offering memorandums or private placements to actually raise funds. We've helped companies with specific kind of commercial agreements or negotiating a lease. Really, whatever your business needs, we're there for you, and we partner you with a female lawyer to kind of develop that relationship at an early stage. And then we try to provide you with really cost-sensitive, high-value service. So now turning it over to Lauren.
So today we're going to go through understanding the stages of capital raising. We'll go through 10 tips for raising capital, and then at the end we'll have time for questions and discussion, but please feel free to ask questions throughout. So there are 6 broad stages of raising capital. For each stage, we're going to consider the typical amount of funding, so the securities issued, the key legal documentation, and the risks. As you progress through the stages, the amount raised increases, as well as the complexity and level of difficulty securing such funding. So there's 2 types of shares that can be issued. These are common shares and preferred shares. There can be various classes and series of these shares which can provide for different rights and restrictions. Common shares typically have a right to vote, a right to dividends if declared by the company, and a right to assets upon dissolution. Preferred shares typically have preferential rights to these common shares, such as rights to dividends and assets upon dissolution. They may or may not have a right to vote. There are 2 markets which securities can be issued. The public market is for public companies who have completed an initial public offering and have obtained a listing on a stock exchange. The exempt market is for private companies issuing securities to investors through securities exemptions. This is a highly regulated process. Such exemptions include friends and family, accredited investors, or private issuer exemption. So the first stage is raising capital through founders of the company with the goal of setting up the company. The typical amount will be nominal and common shares will typically be issued. The key documents will be the incorporation materials, which include your articles of incorporation and any organizational resolutions. And there may be a shareholders agreement to govern the relationship between the founders. The key risk here would be any dysfunction among the founders of the company.
And as Lauren mentioned, what the reason the founder shareholder agreement is often encouraged is to try to minimize that risk of the dysfunction among the founders, so that there's an agreement between the founders up front about what happens down the road in a situation where one wants to buy out another, or one doesn't have the capital necessary to keep the business going forward. If you kind of set those arrangements up front, it avoids a lot of pain down the road. And no one, when they're starting their company, thinks that they're going to have a major issue with their co-founder, but that is a reality that happens a lot as businesses grow and priorities shift, both individually and in the company. So that's a really key document that we encourage people to think about.
The next stage would be to raise capital through friends and family. This would be anyone who's legally permitted to invest under the friends and family exemption, and they'll be investing based on their relationship with the founding shareholders. This would normally be around 100,000 to 250,000, and common shares would be issued or some form of convertible debt. The legal documents would include a subscription agreement in the case of common shares, which would be executed by each friend or family member, or the form of security, such as the convertible debt. Again, there would also be a shareholders agreement for the same reasons that Julie just discussed to kind of govern the relationship between these parties. The risks here would be the valuation at which they purchase the shares at can affect your valuation down the road. Also, if the company has debt, this will be taken into consideration for the value of the company, as well as the founding shareholders will be giving up control when they're issuing common shares.
And just to talk really briefly, one of the first things we did is we kind of said there's common shares or there's preferred shares. But what a security is it's really anything that can be like an ownership interest in the company. So the one thing that's commonly used by early stage companies is a convertible note. And so what that basically means is it's a loan from one person to the company that either, depending on the terms of the loan, either the company or the investor can agree to convert that loan into shares of the company rather than having the company pay back the loan. So that is still considered a security. And so when we talked about the exemptions that are required to trade securities, that even a loan can be caught by securities rules. So just anytime there's anything that touches the ownership structure of your company, you just want to make sure you touch base with your lawyer to make sure that you're documenting it properly, and that you've got the right rule, or you've got the right exemptions in place so that you're not offside any of the Securities Act. And the other thing, the SAFE, I know it's quite hot right now. What a SAFE is it's a simple agreement for future equity. It's a type of agreement that is quite popular in the States and is starting to become more prevalent in Canada. And it's quite company friendly because it allows a future valuation to kind of set the price at what the amount of shares that will be issued under the SAFE, or the amount of money that will be paid back under it. So again, that's something to consider and maybe look into more if you're looking at different options for financing.
In the same stage, it's also securing capital from angel investors, which are affluent individuals who invest their own money, or institutional investors. This would usually be around 500,000 to 1 million, and preferred shares would be issued, or common shares. The key legal documents here are similar to the friends and family. And again, the shareholders agreement would be important in this case as well, just to account for governance between these parties, such as dispute resolution, governance of the company, and preemptive rights. Institutional investors commonly will want a member on the board of directors, so this would be accounted for in this agreement. The risks here are similar to friends and family. It would have an effect on valuation. You would be giving up control if you issue common shares. And in the case of preferred shares, there would be preferential rights granted to these investors.
Yeah, and as Lauren mentioned at the beginning, you know, as the stages kind of progress, the dollar sign typically increases, and with that, the sophistication of the investor often increases. And with the sophistication increasing, you often get more demands from the investor, and so they might come to you with their own term sheet of what they are willing to give you based on these terms, as opposed to friends and family, where you can typically go to them and say, for X dollars, you will receive Y number of shares. And by the way, you have to sign this shareholders agreement. That negotiating power and the leverage starts to shift to the investor with the bigger investments that are coming in. I mean, it's common sense, but just keep that in mind as you're seeking funding.
So the fourth stage is when you're looking to scale your business. This would be capital raised again from institutional investors, but the amount would be higher, from about 1 million to 5 million for preferred shares. The key legal documents, as Julie mentioned, would be the term sheet provided by these investors, a share purchase agreement, which would be the agreement documenting these terms. There'd be a form of preferred share rights, which would set out the share rights that attach to those preferred shares that would be issued to these investors. And again, a shareholders agreement should be in place. Similar risks, once again, would be valuation, and these preferred share rights might be putative to the current shareholders of the company and might not be attractive to future investors.
And just to explain what the valuation is all about, that's basically how much you value the company depends how big of a piece, how big of a stake in the company they get for their investment. So let's just say that your valuation is you're a $1 million company and you're trying to raise 100 grand. Well, then if that 100 grand is worth 10% of your company. So setting your valuation is really important, and for understanding what stake you're going to be giving up as a founder, and what money you're going to be receiving for that. And sometimes, and we'll mention this a little bit later, but sometimes companies really focus on having a really high valuation because then it's a smaller dilution of their holdings. But you always have to be thinking forward to the next raise and the next raise as well. And investors want to see an improvement in their valuation. So if you said your valuation is 5 million and then 2 years later you need to raise more money and your valuation is actually 3 million, it's going to be really hard to get anybody in the door because you've gone the wrong direction. So you want to make sure that your valuations are very realistic and they're projected out.
So the next stage would be raising capital with the goal of building out the company. This would be institutional investors once again, but the amount would be higher, from 2 million to over 20 million. Preferred shares would be issued, and these would likely be a new series of preferred shares. Similar key legal documents again as the previous stage, but there would be new priority rights, which would likely be preferential to the previous investors. And we are looking at the same risks again of valuation and potential punitive preferred rights to current shareholders.
And these institutional investors, so typically you're now dealing with a venture capital firm. It doesn't have to be, but that is a traditional way to raise funds. And there's actually different venture capital firms that will do Series B and beyond raises, as opposed to venture capital firms that just do Series A. Because again, tying back to that comment about the valuation, a lot of venture capital firms want to get in when you value your company at $1 million, because then that 100 grand, 10% of your company is worth a lot more when you're worth $10 million to that first Series A venture capitalist. The later stage investors just have a lower margin, but they also have less risk when they're taking on this investment, because you're more proven, you've got a better product, you really have, your market. So just know, if you're, depending on what stage you're at, you might be targeting different people. And so even though setting up relationships is really important, it might be different relationships that you need at different stages of your company.
So the last stage would be exiting through a sale or an initial public offering. And this provides liquidity for early investors who can sell their shares in the public market after this takes place, or sell their shares through a sale. This happens through either being acquired, which would be through an acquisition agreement, or by going public through an initial public offering. This can be typically up to over $100 million, and common shares would be issued.
And just one thing to note, that $100 million does seem quite big. What we see more often in the BC market is exit through sale. So the acquirer exit rather than the IPO. And that can be anywhere from, it depends on the value of your company, but we've definitely seen, $25 million, $100 million. It really depends on where your company is at. But being acquired by a competitor or being acquired by somebody that wants to get into that market, that's the typical exit. So that being said, in industries like blockchain or cannabis, we do see the IPOs, but we also see things called reverse takeover transactions, which basically fast tracks. You use an existing company that's listed on the stock exchange, and to get and that company purchases your company so that your company's assets are then listed on the stock exchange in a more speedy way. So those are some of the examples of exits that really do happen in this market, and it is a bit dependent on what industry you're in.
So now we're just going to go over the risks that we discussed throughout each of these stages. So dilution and control: as you issue more shares, the founder's control of the company will decrease, as well as their percentage ownership in the company. There will be complications to your capitalization table. If you're issuing many series and classes of shares, this will be complicated, and this might deter future investors. To issue securities in the private market, you have to fit within exemptions, and this is a highly regulated process, so you need to make sure that exemptions are available. Complicated preferred share rights may be attached to the preferred shares that are issued to these institutional investors, and you need to be aware of your available options for funding and the size of that option pool and what matches your current needs. These are the key documents that we discussed. So there would likely be a term sheet with sophisticated institutional investors. Shareholders agreements are recommended at every stage to govern the relationships between these parties. You'll have your articles of incorporation and your preferred share rights. There's also a right of first refusal, which can be included in a shareholders agreement, which is when a shareholder wishes to sell their shares to a third party. Existing shareholders will have a right of first refusal to purchase these shares, which can kind of control the shareholders of the company. You can also enter into voting agreements, which are an agreement among the shareholders to vote in a certain manner on certain matters. And when negotiating these documents, you'll want to keep in mind future funding goals of the company, as these can impair the ability to raise future financing. So now we will move into the 10 tips for raising capital. The first one is corporate structure. It's best to have a simple corporate structure. Startups can have overly complicated share structures to address the needs of various investors. And this can restrict the company's ability to access new capital. Additionally, it's good to keep a good record of all documents. This will speed up future investors' due diligence process, and it will make them feel confident about investing in your company if you have everything organized.
So just on the keep it simple, we often will see companies that when they incorporated, they have common shares with series A through F and preferred shares with series A through F, and they will only have issued common shares series A. And the reason that they sometimes put those in place is they say, well, in the future, an investor might want a preferred share and they might want X, Y, and Z rights attached to it. And what we often see is an investor will come in with very specific requirements, and it's much easier to amend your articles to suit the deal rather than try to what should be articles in advance and then try to put the investor into what you've created. Sometimes it will, more often than not, you still require an amendment to your articles. So we really do encourage the keep it simple mantra. And the keep it well documented. I mean, there are a number of don't hold a minute book, which is a corporate law requirement. And like Lauren was saying, the due diligence process for investors is really key. So they really want to be able to go through your corporate records and make sure that you've done everything correctly. And if you're disorganized, it will slow down and could potentially impair your ability to raise funds.
The second tip is establishing funding rules upfront amongst the shareholders. Founding shareholders might agree to include rights such as a preemptive right, which is the right to have a first chance to purchase any new shares to be issued by the company. But this can be unattractive to future investors as they may not want to go through the time, effort, and money to negotiate funding when the founders have a preemptive right already to buy these new shares that will be issued to them. The next tip is to ensure appropriate mechanisms are in place to settle disputes among the founders. We've talked about this briefly already, but you should have in place a shareholders agreement at an early stage to govern how disputes will be resolved among the shareholders. Investors aren't going to want to invest in a company with unresolved disputes or where there's no dispute resolution mechanisms in place. The fourth tip is to use stock options to reduce the cash burn rate. Employees get tax benefits when they're issued stock options as compensation, and this can benefit the company as well, as it will reduce its cash burn rate as they'll reduce the cash compensation to employees, and this can help when negotiating future funding to have more cash on hand. It's important to note that the exemption that allows stock options to be granted only allows securities to be issued to 50 or less employees.
And just to kind of talk a little bit about what stock options are. So again, they are a security because they can be converted into ownership of the company. So option is typically convertible into a common share. And so when those options are issued to typically an employee, the employee doesn't include the options on their income statement. And instead, they aren't included as income for the employee until the employee exercises the option and they're converted into shares. And so what that usually means is that, or an example of how this would work is a company has 100 grand in the bank. They want to pay 50 grand to their chief scientific officer, but they don't want to use the money in the bank. So they issue 50 grand worth of options. And let's say they value them at 10 cents an option. Well, then the chief scientific officer continues to work for the company, that thereby increasing the value in the company. So now the company's worth more. So when the employee wants to exercise their options, they only have to pay 10 cents to get one share, but maybe the share is worth $1 now. So that 50 grand there's like a big upside for the employee, and the company didn't have to use their cash on hand to compensate the employee. We do have a question that's come in. Can you explain what to watch for when using finders for getting introductions to private or angel investors? So a finder, one thing that you'll want to know about the finder is what commission and what terms they are getting paid. So I see a lot of finders getting kind of like a 6% cut of the deal. But there's one thing that would be really important is they would only get compensated if that deal or if that introduction turns into an investment, and they'd only get compensated, whatever percentage is agreed upon if the deal is successful. Sometimes finders are able to write in the agreement so broadly that if any deal happens during X term, they get paid the cut, whether or not they made the introduction. And that's something we try to advise companies away from. But if you can make those introductions without a finder, that's obviously preferential, because then you don't have anyone to pay. But if you think that it's really worthwhile and there's some sort of connection to either a larger investor that gives you more money than you would be able to source on your own, then it might be worth your while. Please continue to type into the Q&A box if you want more follow-up on that, but that's kind of the general gist.
So the next tip is taking advantage of venture capital tax credits. Investors can receive a tax credit for investing in British Columbia startups, which can be up to 30% of their investment back. There's a registration process for companies to be eligible for this, and there's a number of guidelines and rules, but these can all be found online. Tip number 6 is taking advantage of the scientific research and experimental development tax incentive. This is a tax credit that stays with the company and includes deductions and tax credits with respect to expenses such as salaries, contractors, materials, and overhead. This is refundable if you're a Canadian-controlled private corporation. And again, there's certain requirements that need to be followed.
And just to comment on this one, so I'm working on a transaction right now where a Canadian target you basically make these claims to, or these, you make a shred claim to the government, and then the government would pay a certain amount of money back to the company, and it's considered as a company's assets. And so when you're negotiating the price, in this case, the Canadian company is being purchased by another company, the sale price is adjusted based on the amount of outstanding shred claims. So this can be a really big assistance for you, whether you need it for the operations of your company or even through the sale of your company. And if you do fall within the shred regime, it can be very, very helpful. And what a Canadian-controlled private corporation is it's basically a private company, so not listed on a stock exchange. Canadian-controlled means it doesn't have a significant shareholder that's a non-resident, whether that be a corporation or an individual, so Canadian-controlled. And it's actually a Canadian corporation, so it's like a BC corporation or Ontario or a federal corporation. It's not, it hasn't been created outside of Canada.
The next tip is valuation is not the only important fact when negotiating venture funding. As we previously discussed, having your valuation in mind is a really important factor, and a lower valuation may attract future funding, but it's not the only way to attract potential investors. Investors can also extract value through their preferred share rights to receive preferential rates of return or protections against dilutive financings in the future. Tip number 8 is understanding share compensation. As we touched on with stock options, there's benefits to granting stock options as compensation. When granted to employees, the employees can receive a tax benefit, and when issued to contractors, the company can receive a deduction. In both cases, the company's cash burn rate will be reduced.
And just a little bit of a clarification on employees and contractors. So that is a determination of fact. So even if you have an agreement that's called a contractor agreement or an agreement that's called an employee agreement, that in and of itself does not determine whether the relationship is a relationship with an employee or a relationship with a contractor. So again, if you think that you're dealing with a contractor, but the contractor is receiving salary, works out of your office, has benefits, they may not actually be a contractor under law, and then in turn, you might have to treat them differently. So if you've got any questions about that, I would encourage you to talk to your employment lawyer just to kind of get some clarification on that.
The next step, or the next tip, is considering choosing a funding program. So some things you'll want to ask yourself when thinking about this is, what is the grant needed for? Is there a specific project? What's the benefit of your product or service? What stage of technology development are you on if you are a tech company? Who are your partners and what industry are you in? Are you pursuing any export markets? Could you work with students and universities, the province and municipality that you're in, your partners and your customers, as well as if you have a business plan with financials and other funding to match the grant. The next slide sets out a number of funding programs. There's university-based research programs, industrial research grants and loans, demonstration projects, commercialization assistance, and economic development. These are funding at both the federal and provincial level, and there's a range of amounts that can be granted. The last tip is similar and considering accessing government money. This includes loans, grants, contributions, and other financial assistance available from the government. It's a great way to secure funding without exposure to some of the risks associated with institutional investors. Funding is available for specific purposes, so you'll have to do research to see what is available for your company and the application process.
And one thing that we didn't touch on in this presentation, but just so that you're also aware, are loans. So we primarily focus this on equity raise as opposed to a debt raise. So I guess we did both equity and grants. So a lot of early stage companies are only able to obtain obtain debt financing after they are kind of at least 3 years mature. So often that's kind of why at the early stage we do focus on equity raising. There are some programs like the Women's Enterprise Center that will give loans, I believe at various stages of the company. But I know that a lot of the institutional banks kind of have specific guidelines in place, and you can often get a personal loan, but the company itself isn't eligible for a loan until it's a bit more mature. So that's a whole other kind of topic and presentation that we can talk about. Now, we do have another question that came in about kind of an extension of that finder's question. So the question is, can I use any finder, or do they need to have some form of license or registration? What do I need to ask to do my due diligence? So we definitely have seen finders who are not, licensed. I'm not aware of any sort of registration that the finders go through. Finders are often, it's really just based on the relationships that they have and who they are intending or who they're representing to introduce you to. In terms of what you need to ask for your due diligence, it's very fact specific. So it depends on how much you're trying to raise, who you're trying to raise from. I think it would be helpful to have a good sense of if they've acted as a finder for other entities before, what sort of success stories that they've had. Yeah, it really is relationship based. So as much kind of background checking you can do on who they know and what previous success they've had is probably the best place to start. Another question that's come in: can you explain what it means when the headlines say so-and-so raised X through or through capital. Is that a finder? Okay, often not. Often that's actually an underwriter or an agent that acts on behalf of the company. So often, particularly in the public context, which is what Lauren and I work a lot in, is you'll have what's called a syndicate of banks. So I'm just going to use the public company example. So let's say we've got Aritzia, and Aritzia wants to raise $100 million. What Aritzia will do is it will have an investment banker, and let's say its investment banker is CIBC. CIBC would then be the lead underwriter on that $100 million raise, and they would probably work with a number of other banks. So that's called the syndicate. So they might work with TD, RBC, Raymond James. There might be a whole group of banks. And those group of banks will each kind of decide, okay, I'm gonna sell $20 million worth of shares to my group of people, and I'm gonna sell 15 million worth of shares to my group of people. And that's what that's what they say something is raised through. It's often that underwriter is the person that's actually finding the actual purchasers. And so is that a finder? It kind of is, but it's not really when we see in the legal context a finder's fee agreement. That's usually more like a smaller scale direct introductions, as opposed to kind of agreeing to sell on your behalf, which is what the underwriter is or the agent is doing. So a finder can find you the investors, and an underwriter or agent will actually like set up the investors and will typically kind of make sure that they find that or fill that entire round. So if you have any other questions, please type them into your question and answer bubble, or if you're able to come online. We do have another 20 minutes or so.
Hi, Julie, it's Carrie Lee. I see in the chat here, there was a question. One of the participants is asking for you to explain again the reverse takeover transaction to get listed.
Oh, I did not see that.
That's okay.
Okay, so a reverse takeover transaction. So a number of, like the reality is that industries go up and down, and the mining industry used to be quite strong, particularly in Vancouver. And when the price was quite high, there were a number of junior exploration mining companies that were able to operate and be profitable. Then when the price of gold went down, it was no longer profitable for them to operate. So a number of those companies that were already listed on the stock exchange just kind of became dormant and really kind of turned off the lights. They did the minimum that they needed to do to stay listed and stay in compliance, but they didn't actually operate anymore. So we call those a shell company. And there could be other forms of shell company, but this is just a real world example of the Vancouver market and kind of what we've seen. So now you've got a shell company that's been dormant for, let's say, 8 years. And we've got this new cannabis company that's up and coming, and it's got a huge valuation, and its assets are looking good, and it's got a strong management team, and it doesn't want to go through the process of an initial public offering for whatever reason. It thinks it'll be too long, it thinks it'll be too costly. And this shell company has some money in it. It doesn't really have any other assets, but let's say it has $5 million in it. The shell company will purchase the cannabis company for that $5 million. So basically what they're bringing to the table is funding. And what the cannabis company is bringing to the table are assets and a product. And it's called a reverse takeover because even though the shell company purchased the cannabis company, it's really going to be now the cannabis company that's listed on the stock exchange because that's the assets and the operations that are going forward. So often what happens is then the name of the shell company is changed to that cannabis company. Its management is now the cannabis company management, and away they go, they're listed, and it's a faster and profitable way to kind of go forward. Okay, I've got another question about I need to raise 150K for my pre-seed, but this is really out of my element. Is there a company or a person that I can hire or partner with that can do this for me? So I'm not sure what market you're in. I know that there are companies in Vancouver that will help early stage companies kind of work through their financing. I know that there's also companies like FrontFunder out there. That's a web-based platform that will also help companies do their or put together their financing, but you will still need to be involved. So for instance, FrontFunder, although they can put the documents in place and they can kind of help guide you through what you need to do, you're the one that's going to have to still find the investors that actually put the 150K into your pocket. And we've been talking a lot about these finders. There are other companies out there that can kind of help find those investors for you. If you can find an angel that will champion your company, then they will often talk to other angels and you might be able to raise through what's called a lead investor. But again, that's all relationship based and it really depends on what market that you're in. But there's definitely, you can hire people, but for $150,000, the cost of hiring people is going to be a fairly sizable amount. You can also work with your lawyers, but again, they can only put the documentation in place. They won't actually be introducing you to the investors. And again, there's kind of a minimum cost for their time. And unfortunately, it's not a sliding scale. So whether you raise $1 million or 100 grand, their fees are going to be comparable because the documentation and the work that goes into those two raises is quite similar. Another question is, what's the best way to find a finder? Are they independent individuals or work for companies? Both. There are some companies that are finders, and then there's other individuals that just hang out their own shingle. Again, it depends on what market you're in, and not just what market you're in, but also what industry you're in. So even if I threw out names, like it wouldn't necessarily be relevant here. So the best way to find a finder, honestly, I would just talk to other people in your industry, in your market that have raised, and try to pick their brain about how they found investors, or if they worked through a finder, or how that process looked for them. And that way you'll be getting actual localized information rather than kind of general comments from Vancouver. Anything to add?
No.
Julie, it's Carrie Lee again. I just wanted to go back and briefly touch on the grants that you guys mentioned. And there are a lot of really valuable grants that are out there, but one thing we always caution women entrepreneurs too is when you're applying for a grant, potentially a private grant or something that you find, there should never be a fee that you have to pay up front to get the grant. Typically those are the ones that we want to stay away from. So I just want to caution everybody on that. If you're being asked to pay any money up front, I would really do some due diligence there and find out what that is, because typically a grant, you don't pay anything to get that money.
That's a great point. Thank you. And again, it's hard because I don't have a sense of the audience. I don't know what industries you're in or what markets you're in. But the grants that are available to you can be very different depending on where or what your business is. And also, the Women's Enterprise Center, one of the things that they offer is mentorship. I know that there's a number of other organizations that also have that kind of community building aspect, and that's really key. Again, if you're talking about how do I find a finder, talking to your mentor and getting some sense from them. There's also organizations like the Forum for Women Entrepreneurs, and they've got their Pitch for the Purse coming up. And that can be a good way, again, if you're looking to raise, a good way to kind of improve your pitch and get those introductions and get that publicity as well. That can be huge. There's also SheEO, which is a great way to get access to it. Again, it's a loan-based program, but that is a way to increase your funding and, again, increase your network. I know a number of companies that have gone through that, some of which went through SheEO, then were successful at Pitch for the Purse at a later year. So getting that exposure and those networks can really help you. Another group that I want to talk about, and I'll put this into the chat just so you have it, is called the Lazaridis Scale Up Program. And basically what that is it's a program run out of Waterloo where they select, if you're tech-based, a Canadian tech-based company, they select up to 10 companies for each cohort, and it's free. And it's about a 6-month program where once a month you either go to New York, Palo Alto, Vancouver, Toronto, and have sessions with real people that have gone through it. You know, I've been to sessions where there are Facebook execs or Google or like you name it, they've kind of walked the talk. And again, those networks can be really huge, and just talking to other companies that are in the tech space across Canada can be really, really helpful. So again, I'll put that in the chat bubble, but they, I think, are accepting applications for the next cohort until August 8th. And again, that it's a free program that can really help scale your tech company quite quickly. See if there's any other questions. Do you have any specific suggestions for raising funds for a film or TV show? Unfortunately, I don't. I know that there are some other lawyers in our firm that do work more in the film industry. I have had discussions with some people that are working in the film industry, and again, from talking with them, it does seem to be based on those personal relationships that they've had and often previous jobs that they've had. But unfortunately, I can't give you any specific suggestions on that front. Another question came in. How do you go about getting your company valued? That's a great question. So there definitely are organizations that can help you figure out what the valuation of your company is. There is no magic though. So what you basically do is you look at your current financial statements, and you kind of look at what your projected growth is, and the evaluation is a bit of a finger in the air trying to figure out where you think your company is going to go at what time. So there's no, like I said, there's no magic to it, but there are a number of people that do help companies figure out what that valuation can be. One of those companies is called, sorry, I'm just blanking. Who did the pitch next? Valuation. Valuation Advisors, based out of, here, I'll type that into the chat. Valuation is based in Vancouver here, but that's one thing that they can do. They can help you figure out what your valuation will be, and if they don't do it specifically, they can kind of connect you to the right people. Sometimes your accountants would be able to help you with that, but not all accountants would be comfortable. Again, sometimes it kind of depends on what you want your raise to look like and what you're using your valuation for. But sometimes your valuation is also informed by what are people willing to pay for my company, for what percentage of my company. So it's not a science, and it should be informed by your current assets and your current financial situation, and also your projections of where you think you're going to be. So we're just waiting. If anyone else has any questions, please do type them into your question bubble. I think we've got another 10 minutes or so.
Julie, I see one question again here in the chat just asking about resources for drafting shareholder agreements. Wondering if there's any kind of, I'm going to call it the self-help, or is that something that really you should talk to your accountant and lawyer when you're drafting those up? What's your recommendation there?
So typically we would recommend to start with a lawyer. One thing that companies sometimes try to do is they try to use a form of agreement and then try to finalize it as best they can and then send it to their lawyer to kind of do one final read. And often that's more expensive than just having the lawyers do it from the beginning, because what happens is we have precedent documents that we've reviewed a number of times before or have already been vetted, that we know exactly what's in it and what's not in it. And for us to review a form of agreement, we have to kind of go through that whole process again. And so it takes a lot longer, and so it costs a lot more. So you think you're saving money, but you're actually saving money if you just say, look, I want the shareholders agreement to cover A, B, and C. Typically your lawyer would say, would you also want it to cover D, E, and F? You have that conversation, they go away, they put something together, and then you've got something that's good to go. Anytime you're working with a lawyer, a way to keep your costs down is to avoid the number of turns of the document, so the number of comments that are going back and forth between sides. So if you've got a sophisticated investor that is going to really be controlling and is going to have a lot of comments, sometimes a good way to go about it is have them draft documentation that they sign off on, and then you can kind of just push back and finesse what you really need to push back on, as opposed to you putting something forward that's maybe middle of the ground and then completely, rewrite it, and then your lawyer has to get re-involved. And so you want to think about negotiating power and think about who wants to control the document. There are definitely form of agreements out there, but they're all very different. And so even in our startup package, we include a shareholders agreement as one of the kind of key documents you want when you're starting out your company. But that's a founder shareholder agreement. And that founder shareholder agreement is going to look very different than the Series B shareholder agreement if you already have, let's say, like 30 shareholders. So even though it's called something, and if you find an example out there, it might not cover what you need it to cover. So we recommend going to your lawyer, and there's so many different options. You should always feel like you've got a trusted relationship with your lawyer. You can definitely, before you choose who you go with, it's good to meet with a couple of different people, kind of get some price estimates and really feel confident in who your relationship is, because it's not very helpful for you or the lawyer to bounce around, because it takes lawyers time to get up to speed on what your company does, what's important to you, what's the structure of your cap table, and other things. And I'm not seeing the chat. I'm only seeing Carrie and our comments in the chat. So if there are other questions that came in on the chat and not through the question and answer bubble, please do let us know.
Oh, I think we've covered all of those, which is great. We did just have one comment that the slide that you have up right now is hard for everyone to read. So hopefully when this is recorded, that might come in a little clearer, because I'm seeing it and can read it. So perhaps it's just a connection issue. So hopefully that will be okay. And that's the some of those funding options that are out there. So we'll make sure that we maybe we can cut that slide and save that as a document to send out.
Sure.
Perfect. So yeah, just a couple more minutes left. We'll leave the Q&A open. So if anything does come up, please pop them in there. And then we'll go through as well some of these follow-up questions. And I don't know, Julie, you see those questions popping up now. If you want to jump in and take care of those before we finish up, we do have another 5 minutes.
Sure. Yeah. So I think we've covered most of them, but is there a chance of getting all the slides? I mean, we're fine with sharing the slides. Carolee, if you're okay with distributing, or if there's a way that that's no problem.
Great.
And can you talk a bit more about the cap table? Do you have an example? So a cap table is basically your the ownership of your company, if you think about it like that. So your cap table will include all of your shareholders if you had any convertible notes or any option holders, it would kind of be anything that's a security is part of your cap table. And why that's important is it shows the ownership of and the breakdown of the company. And there's what's called, there's the diluted and there's the non-diluted. So the diluted would be if every convertible security, so every option, every convertible note actually exchanged and converted into common shares, that's the fully diluted number. So, you know, if you or the founder, and let's say you own 100% of the common shares, the non-diluted ownership of the company is 100% you as the founder. But let's say you've got 10 employees that have options that, you know, they've each got 100 options, and you've got a convertible note that's converted into 300 common shares. Well, then when you did the diluted numbers, you would consider each one of those 10 employees to have, instead of options, you consider them to have common shares. And similarly, you consider the convertible note holder to have those common shares. So now instead of owning 100% of the company, maybe you only own 60%, and maybe option holders own, you know, together they own 20%. The math isn't quite right there, but you know what I mean? Like there's, the cap table should kind of capture both diluted and non-diluted. And if you just Google cap table, that's probably the best way to see an example, because we don't have one kind of in our slides that I can talk to.
There's another question here. What's the name of the incubator that you have talked about?
Well, so there's the Scale Up program, which was helpful. There's SheEO. I'll put that into the chat. And that's the one that it gives you the loan that you then pay back. And you're basically one of, I think it's now up to 6 or 7, maybe one of 7 Canadian companies that receive funding each year. And then there was also the Forum for Women Entrepreneurs, and they do Pitch for the Purse. Did I mention anything else?
Thank you. Perfect. It looks like we've got all those questions answered, which is great. So I'm just going to scoot back over here and grab the screen. So hopefully everybody can see my screen now as we do our quick wrap up and thank you. So again, you know, thank you so much, Julie and Lauren. Lots of information and good tips shared today. And thank you for offering to send out the slides as well. I know that's beneficial. So as people are listening to this again and going through, they can make some notes or just have that as a reference. So thank you very much for that. And then again, reminding everybody, we will send out a follow-up email. So we'll put those slides in there, some of the links and things that we shared in the chat today as well for you. And also I'll send the link to our loans page so you can take a look there and see if a Women's Enterprise Center loan might be something that you need as well. And also just a quick follow-up survey. We'd love to have your feedback on these events and again, learn about, you know, what other type of topics and speakers we can bring in to support you. So again, thank you, Julie and Lauren, for the excellent content today. And again, as you can see on your screen, the next few free sessions that we have coming up on email marketing, selling your services to the government, and then again, our BLG Driven by Women series on August 14th, talking about commercial leasing basics. So that'll be a great one. And then the final in the BLG series is on September 18th. And we're going to talk about letters of intent and confidentiality agreements. So those also can be very important as you're raising capital as well, some of those confidentiality pieces. And again, registration's open for all of those on our website as well. So without further ado, we've come up on 11 o'clock. Our timing is perfect today. Thank you, Julie and Lauren, and thank you everyone for joining us. Also, sorry, in the follow-up email tomorrow will be the link to this recording so that you can go back and listen and take a look. So thank you everyone for joining us, and I hope you have a great rest of day and hope to see you back online here again for one of our future sessions. Thanks everyone. Have a great day, Lauren and Julie.
Thank you.
Thank you.